if you have any questions, or maybe Maria or Attorney Te want to say something first.
Ted first. Ted, I had McDonald's. I
Oh,
hope
okay.
you ate a little bit.
Sure. Yeah, I have a meeting. I'm outside. That's why it's a bit noisy. So yeah. Well, today was set for arraignment at 10 o'clock, but we had filed a motion to quash earlier on December 2, though we set it for hearing next Friday, December 11th. And so we asked that the arraignment be deferred until such time that the judge could rule on the motion to quash. The judge gave the prosecutor a period. Well, she actually didn't give the prosecutor a period. She just asked the prosecutor to submit his comment before the hearing on the 11th. So, so we will wait for the prosecutor to submit his comment on the motion to quash. Though we are attending the hearing on December 11th. That's basically what happened this morning.
I will say one thing, and this was something I don't know if I tweeted it this morning, but I meant to. I'm shocked, and Ted will tell me if I should shut up about this. But what's shocking to me is that the prosecutors have forwarded it. I was surprised when it became a case, a criminal case, and so in that sense, I guess I've always said that we are going to fight all of our cases in court. We submit ourselves to the court, but we also, for every single one of those, have signatures for each one. And I feel like we will get justice. You know what, that Martin Luther King quote, the arc of the moral universe is long, but it bends towards justice. So the city prosecutor who did this was Mark Anthony Nugget, and it was approved by Aris Mangera and then submitted to the court on November 23. Um, I've posted bail. An arrest warrant was issued Friday last week. Uh, I just barely made it to post bail, and we were there today. So uh, you heard what I said outside the court. I just said it's crazy that I have to face a criminal case for tweeting a screen grab of a newspaper article. By any stretch of the imagination, that just seems off. So that's why we have a motion to quash. Did I say too much, Ed?
I think Mikha, you have a question?
Yeah, thank you.
Just unmute yourself na lang. Yeah.
Good afternoon, Maria. Good afternoon, Attorney Ted. Attorney Ted, I just wanted to clarify on the legal procedure that happened this morning, because today is your scheduled arraignment, right? But since you have a motion to quash, was Maria actually arraigned? Did she enter a plea or not?
The arraignment did not push through. It was deferred because the motion to quash was filed, and so under the rules, the accused has the option to file a motion to quash anytime before arraignment, and so that's why there was no arraignment, because the motion to quash was filed in time. So we will wait for the motion to quash and see what the judge does.
And the December 11 setting of the hearing, is that when the judge is expected to rule on the motion to quash, or is it just a hearing?
We don't know. We set it for hearing. I mean, we're required to set a motion for hearing. So we set it for hearing on December 11th. We don't know the judge will rule.
Okay. How about the deadline set for the prosecution to comment on your motion? When did the judge set the deadline for that?
The judge did not give a period. The judge just told the prosecutor file it before December 11th.
Okay. And one last question from my end, Attorney Ted. What's the status of the appeal of the first cyber libel conviction in the Manila court?
Oh, that's pending. We have not received a notice to file brief, so we are waiting for that.
And it's with the Court of Appeals, right?
Yes, it's with the Court of Appeals.
Sure. What's the latest issuance, or what's the latest what's the latest issuance from the court on that appeal?
Again, we have received received a notice to file briefs yet. So we are waiting for that. That is what we're waiting for.
Okay.
Under the rules, we will be directed to file briefs. So we have not yet been directed to file briefs. So we are waiting for that notice.
Okay. All right. Thank you, sir.
But we've filed it at the Court of Appeals, right, Mikhail? We filed it.
The notice
yeah.
notice has been filed, but the briefs have not been filed.
So you're just waiting for the court to issue the notice to submit briefs, right?
Yes, that's right.
All right. Thank you, sir.
Okay, I think Howard is raising his hand kanina. You can just unmute yourself and ask the question.
Hi, everyone, again. Just a quick question about the 11 on this current case. If they are happy with the prosecutor's comments and they've obviously received yours, could it be hypothetically that they, in the worst case scenario, they do arraign you on that day? Could hypothetically they do deal with the comments and do an arraignment that day?
The arraignment has to be set, so we will have to wait for an order. We don't know. Again, I don't want to speculate on what the judge can or cannot do. The 11th is set for the motion to quash hearing. If the judge wants to arraign Maria, she will have to issue an order directing Maria to appear on the 11th. Until we get that order, then we will presume there is no arraignment.
Okay, thank you. That's great.
All right.
I was just wondering, hi, it's Yara here. Is it okay if I ask a question?
Go ahead, Yara.
I was just wondering, in terms of cyber libel and this case in the wider Philippines community at the moment, are we seeing more cases of cyber libel being brought up against other journalists? Is this unusual? Is this cyber libel sort of case unusual, or are you seeing a lot more of this happening in the Philippines?
Maria, maybe you should take that. I don't know how many more cases. Go ahead. Go ahead, Maria. I'll follow after you.
So we have no idea, Yara, right now, right? But certainly, I seem to be getting two in this one. But it's a test because the cyber libel law was controversial to begin with, and our first cyber libel case was certainly, the move of shifting the period of prescription from 1 year to 12 years. And then in the response, they brought up 15 years. This is all novel and new ground. So Ted, what do you think? I mean, in terms of the number of cases, I wouldn't know because there isn't really a central database. I mean, Rappler or journalists, reporters. Do you guys know of others? I think there have been a few, but I think Ted would probably know better.
I wouldn't know the exact numbers, but I do know that since the cyber libel provision in the cybercrime protection law was affirmed in 2012, Maria's case in branch court of Manila, which we are appealing in the Court of Appeals, is one of the few cases to actually deal with the substantive provisions of the law, which is prescription. So that is an issue we're appealing definitely in the Court of Appeals. Now, this particular case in Makati deals with yet another substantive aspect of that law, which we questioned in 2012. Rappler and Maria, Glenda, Chai, they were among those who filed a petition in the Supreme Court to question the constitutionality of the cybercrime law, including cyber libel. So this particular case brings up yet another issue in the cybercrime protection law in relation to cyber libel, which is the sharing, reposting, retweeting of a statement written by another on social media, which precisely was addressed by the court in the Bikini case, the only case so far to have raised the issue of constitutionality of the cybercrime protection law and all of its provisions. So, in a sense, how many years has that been? Since 2012, it's 8 years, a little over 8 years. this is now an opportunity once again to raise the Dicini case in the this time in the trial court. So yeah, we're hoping that the Dicini case, which we have cited in the motion to quash, will be upheld by the RTC, because that is what the Supreme Court has said, that if you share a post on social media that you didn't write, if you retweet a post on social media that you didn't write, then you cannot be held liable for sharing or retweeting that post. The only time you can be held liable is if you yourself made a defamatory post, which is not the case here.
But can I pull broader also from the law itself, like in terms of in 2012, actually, I joined Rappler joined TED in challenging the cybercrime bill law at the Supreme Court, and what we brought up in 2012 is that this can be used as a tool to curtail press freedom and to harass and intimidate journalists, which is, I think, the case in my case for sure. So look, keep it coming. We're gonna fight it, but it's just ironic, we saw the danger coming. We called it out. There was a TRO at the Supreme Court that the Supreme Court released, and here we are today.
You keep saying, Maria, you've repeatedly said that you're going to stay in the Philippines and you're going to fight this. But how do you keep fighting something when the rules of the game keep changing on you? When, for instance...
No, you keep reminding them what the rules are. You keep reminding them. Ted keeps writing it. Dicini, because hold the line. I know that the Trumpers kind of took that, but we were using hashtag hold the line from the beginning, because that's what we have to do. And it's not just us, all the journalists working here have to constantly do that, the same way that we've seen Western journalists have to grapple with Trump's lies. Filipino journalists have called out Duterte's lies, and we've been doing it longer. There are costs for sure, but it's also, this time matters. And I think all of us would regret if we didn't hold the line, because then we're abdicating, just like tech platforms. No, we're abdicating our responsibility, the reason why we became journalists.
Thanks, Maria.
Go ahead, Howard.
Hello. Hi, Maria, Attorney Ted. Just this morning in the radio interview, Mr. Kang's legal counsel, Attorney Cruz, has been consistent in saying that the tweeting of the screenshot was not merely a retweet, but it's actually a fresh publication of the article. What do you say to that? And the counsel also was saying that it was Miss Maria Ressa who first published the screenshot. So if Miss Maria Ressa had not posted it, other people would not have known it. What can you say to that? This was this morning.
Yeah.
In the radio.
So right off, fact check. I wasn't the first. I know several journalists who did it before I did. In fact, I was holding back precisely because he had filed a case. I had just been arrested. So that was like, if you remember the days, right? What happened was Kang threatened to sue the Philippine Star, and the Philippine Star on Feb 15th said that they would take the article down. On Feb 15th, the article still existed online. So lots and lots of people, and I can name a few journalists, but I don't want to name them because then, then he might be crazy and file against them. But it's a normal practice of journalism. So, you'll have to deal with freedom of the press and freedom of speech and freedom of expression, constitutional rights. So that's the first fact check. I think the second one is everyone tweets articles, right? So what I also do know is that the article was taken down by Star with a statement by Star saying that they are taking it down, not because it was factually incorrect, but because, that I added. What their statement said that they were taking it down because of the threat of legal action against them. That was on Feb 16th, the day of the tweet.
Yeah, let me just
I,
address the statement as regards
Fresh publication.
the legal implications. Perhaps they should comment on the motion to quash. It's been raised. So the scene is pretty clear. The court was very clear in the scene. So I won't since we've submitted the motion to quash already in court, and the court has directed the prosecution to comment, then maybe they should just comment. But they can read the scene repeatedly, and it's there.
Thank you.
Sana kung byline ko yun, no? Then siguro meron sila. Sorry, shut up. Get that from Ted.
Howard?
Yeah, this is just to expand on that quick question I asked you, Maria, this morning, and also Ted, if you could answer this as well, is what effect will this have on tweeters and Twitter users in the Philippines? Is this a test? Will this be a test case for Twitter users?
Ted first on this, and then
well, yeah, I would suppose because again, this was precisely the issue that the court addressed in the Vicini case, that in relation to cyber libel under Section 4C4 and aiding and abetting cyber libel under Section 5. And so the court upheld cyber libel as an offense in that Vicini case. Well, we disagree with that, but well, that is the ruling of the court, so we have to live with that until the court changes its mind. But the important thing is Section 5 of the law in relation to cyber libel, aiding and abetting the commission of a cyber crime, and the court precisely pointed out that in relation to cyber libel, the posting, the sharing, the retweeting of anything on social media might be considered as aiding and abetting. And the court said, that is too broad a definition. No one will understand what that means. And so if you criminalize the sharing, the posting, the retweeting of anything that you did not write on social media, then that contradicts the nature of social media. And it also places people in possible jeopardy of being criminalized for an act that they did not realize was criminal. And that's why in the Vicini case, the court struck that down. It said that's unconstitutional. So you cannot enforce Section 5. It no longer exists legally because it has been struck down in relation to cyber libel. Very specific in relation to cyber libel. And again, in that case, that was pointed out. The court even used an example. And well, maybe by some weird stroke of irony, the court even used the name of Maria as an example. She said Maria posts on Facebook, something like that. If you read the case, it's there. Of course, the court did not mean it to be Maria Ressa, but the court even cited an example of someone reposting on social media and said, this is the danger of criminalizing reposting, sharing, retweeting, if the statement isn't yours. Because then on Twitter, on Facebook, on social media in general, people who basically just do that, right? That's how it is on social media, would be in danger of being criminalized, subjected to criminal penalties, without really realizing that what they did was criminal. And so that's why the court struck that down. And we argued that in the motion to quash.
I think that in harassing me, in focusing on this is a bad precedence for social media, for Twitter, precisely because this means that think of all of the half lies that others, not news groups, have written that have been shared or screen capped. And I can, point to President Duterte supporters who have done that. There's so many layers to this, right? Because they would have to prove that the original article, which I didn't write, is libelous. And then the second one is they would have to prove that something I did write is libelous and everything that I wrote is a fact. It's like a few sentences. Unless they don't like the hashtag, they would have to prove that's libelous as well. So look, I mean, it's a test case. it's the wrong test case because it takes us down the rabbit hole of the wrong direction. Whoop. So let's see. Ted is more, he'll give you the laws of it. All I see are the dangers in these types of actions that set bad precedents for an entire population of 109 million people on social media. We have 72 million Filipinos on Facebook, 72 million accounts. And we know the kinds of disinformation that is on there. And we've been talking a lot about the disinformation network, some state-sponsored, the red tagging that is there. Our intelligence chief is actually tweeting and posting some of that. What does that mean? Is that cyber libel? This is very dangerous.
Thank you.
Can I ask Bea?
Go ahead, Ms. Leah.
Attorney Ted, procedurally, could you take the Makati prosecution's probable cause, go to the Supreme Court and file a petition for certiorari on grave abuse of discretion? Because I'm thinking the sooner that you raise it to the Supreme Court to clarify the constitutionalities of it, the better for everyone para wala nang sumunod. Pwede ba yun?
Is he frozen? His battery. He just texted his battery died. We can come, he can come back and you can repeat your question.
Okay. Guess my second question for you, Maria, is this expectedly when you are arraigned, this will be an addition to the court that they have to seek approval of when you travel. So you will now have 5, 6, 7, if I'm not mistaken, I'll just go back later, 7 courts to seek permission from. How are you taking that? Panibagong papaalaman pag magte-travel.
I think you know that I'm in a battle now to fight for my rights. That's a very easy battle. And it's one that is, I'm going to go full steam ahead because look, this is an asymmetrical battle when the president of the country or when a government runs after one citizen. That's called asymmetrical warfare. It's, I guess in this one, I have been denied travel twice by two out of 6 courts, 2 out of 6 criminal cases. Right, so you know how many courts they're in. So we're fighting for the right to travel, and in the next level of what happens next, I don't know. Right, I had actually asked. I have different lawyers for different cases, but one of the other lawyers I'd asked, so what else can be filed, and he just laughed. He said, well, don't think about that because they could file child abuse. So maybe that one I shouldn't say, but anything can be filed against you. And this is why I believe every citizen, and this is me speaking not as a journalist, but as a Filipino citizen who is demanding my rights, and that I'm seeing grave abuse of power in the government's focus on me and our journalism. Take a look at everything that we've done. It remains fair and balanced. I hate that word. No, let's not use that phrase. But we keep doing our jobs despite this. What does that mean for me? I don't know, Leah, and I take everything a step at a time. I just take it this way, right? I know the North Star. The North Star is this is happening because we're journalists. I'm a journalist who is refusing to shut up. But doing these types of tactics only gives me more evidence of the kinds of abuses of power, the legal acrobatics that could happen when you don't follow what the government wants you to do. And that's not what happens in a democracy. So yeah, we fight for our rights. This is it. This is the moment.
You intend to keep asking for your right to travel. You're not gonna stop just because there's an additional court.
Absolutely, right? Like I'm not gonna voluntarily give up my rights. I've dealt with bullies when I was in elementary school. I don't like getting bullied, and I get stronger. Sorry, I will shut that. That might have hurt your ears.
Maria, just for the record, when did you file bail and how much was the bail set by the court?
Last Friday, and I posted 24,000 pesos bail.
So shortly after you received the warrant of arrest, you immediately filed bail.
We had our lawyers constantly keep in touch, and they had been told that the warrant of arrest had been issued. I immediately dropped everything to go to court before it closed. Remember, because courts now close at 4 o'clock to be able to post bail. If I hadn't been able to make that, then that would have been 4 nights. That was a long weekend. So I wouldn't have been able to post bail until Tuesday. And I'm a little bit allergic to this because February 13th, 2019, we had the NBI come to our office at around 5 o'clock. And then, the information at that point, the arrest warrant didn't even have bail, like the amount to post bail. So I was forced, they essentially detained me overnight because of that. I couldn't post bail until the next day. That was the Valentine's gift of the government to me. So yeah, that's it. I answered your question. Sorry.
Right. Thank you, Maria.
Thanks.
Hi, Ben.
Attorney
Can I
Ted
ask?
yeah, wait. There. Balik na si Attorney Ted. And there you go. Lian, if you want to continue your question, if you want to redo your question,
did you hear my entire question, or sir wala ka ring audio?
Naka-mute ka, Ted.
Yeah. Good. Okay, here.
I have to repeat it.
Yeah, I didn't catch your
sorry.
question. You got cut off just before you were about to ask.
Okay, sure. Procedurally, is it pwede ba na take the ruling, the probable cause ruling of the Makati prosecutors, go to the Supreme Court, file a petition for certiorari on grave abuse of discretion, and challenge yung interpretation nila ng Dicini? Because I'm thinking that the sooner that you challenge the constitutionality and the interpretation of Dicini, the better it will be for everyone else who may be charged under the same interpretation.
We have to go up to the DOJ first. We have just received officially the resolution, so there is a period of time given to elevate it to the DOJ for petition for review. We can't go directly to the Supreme Court. We have to go through the DOJ. So that's the procedure. So petition for review, DOJ, and then all the way up. So that might take a while. So the question of interpretation of the Dicini can be addressed as well in the court itself, because you can raise the question of constitutionality anytime in any court. So but not to say that we're not considering elevating it to the DOJ, but of course we will study what's going on, because we may not need to elevate to the DOJ if the court quashes it.
So you're looking at it like the regular procedure, which is yung motion to quash a court and taking it.
We have no choice.
In Maria's case.
We have no choice. We have to go to the regular procedure. We don't want to give any reason to junk it just because we didn't follow procedure. So we have to follow procedure. So we have to go step by step.
Okay.
Hi, Bea. Can I ask? This is Mike.
Go ahead. Sige, go ahead, Mike.
Hi, Maria. Hi, Sir Ted. So sorry, I'm on the road. The signal's spotty, so I keep my video off. I just wanted to ask about your thoughts about the judicial system's ability to keep up with technology, because I note that in finding ill motive in Maria's tweet, the Makati City Prosecutor's resolution cited a 2008 case denying the libel conviction of entertainment journalist Christopher Min, but this involved a 1995 tabloid article. It was not a tweet. It was published 7 years before the Cybercrime Prevention Act. Now, in convicting Maria, the Manila court also had to cite a 1988 case on the concept of republication. So what can you say about the judicial system's need to rely on precedents? And what does this say about courts' ability to keep up with the times?
Yeah, that's a good point. we can't raise that in the motion to quash because we have to raise the issue as it appears. But should we go up to the DOJ on a petition for review, those would be the points we would raise. And so definitely there is some concern about the authorities being cited by the courts or by the prosecutors because again the Fermin case, as you pointed out, that didn't involve the cybercrime case. That's why we keep going back to the CINI because again. Whether the courts like it or not, or the prosecutors like it or not, the CINI is the only case so far by the Supreme Court that has squarely addressed the issue of cyber libel insofar as constitutionality, consequences, and even its application to social media and online journalism. So we have to go back to the CINI. And so again, with due respect to the prosecutors, to the courts, the situation is different. Online publications, online journalism, online conduct is different from, example, print. And there are fundamental differences there. The court in the CINI recognized that. So yes, those would be arguments that we would definitely raise in questioning the findings of the prosecutors. And should we go to trial? Should we be compelled to go to trial because all of these procedural matters are dispensed with? Then definitely those are legal issues that we will raise because again when Congress passed the cybercrime protection law, it made a statement that we are using technology now and therefore we need to address the problems brought about by technology. It would be ironic if in addressing a prosecution under a technology motivated law, we would go back to the law pre-technology. So again, that's a good point, and we will definitely raise it at the appropriate time.
I wonder if Maria has something to say about it also.
I mean, in that one, Mike.
Hello, Maria.
Yeah. So I hope that the courts are ready for a slew of others, right? If they actually, so this is now up to the judge and our motion to quash. But imagine, this is standard practice on social media. People take screenshots and then they post. And will this open up a whole? It's like the dominoes, right? Because imagine how many cases of cybercrime could be filed, and again, is it really on the side of justice or is it on the side of harassment? I mean, sorry, that's not a very good way of stating it, but essentially they're opening the floodgates for something that doesn't take into account norms of behavior on the social media platforms. And if they don't do that, then they could declare something illegal that is normal practice, right? So I think there's a fundamental difference between print, say, and the internet. This is part of the reason we're dealing with all of these global issues of how to regulate the social media platforms, and where are our rights as the users of these platforms. So I hope we, as a country, as the judiciary, looks at this with the nuance and sophistication it demands, so that we don't set in place, we don't move in the wrong direction as a nation.
All right. Thanks, Maria. Sir Ted, just as a follow-up, former Assistant Secretary Hieronymus C. Said that the reason why there are some problems about the cyber libel law is because it was actually a late addition. They did not include this in the draft of the Cybercrime Prevention Act. It was added by politicians, by the senators and congressmen who passed it into law. Would you agree that this has contributed to problems in terms of interpreting the provisions of cyber libel law? Because it wasn't very clear. For instance, the concepts on prescription, the penalties, for instance. Would you agree with this assessment?
Well, I've heard that. I've heard that. Theory. that it was a late addition. But again, it doesn't. It wouldn't really matter because they did include it in the law. And we are entitled to presume that when Congress passes a law, Congress knew what it wanted to do, and that when it passes a law, the law is complete in itself. That they've studied the law and they understand the consequences of the law. Of course, many times we've discovered when a law is challenged in the Supreme Court, and the Supreme Court makes a ruling that it turns out that maybe there were some lapses. So I've heard that theory actually being advanced, that it was a late addition and they didn't really study it well. If that were true, that doesn't reflect very well on Congress. And so I might, if I may be allowed to say that, it doesn't reflect very well on Congress that it passed a law that it didn't really fully understand, right? So yeah, but it doesn't directly make the law defective until the court declares it to be defective. But it does place things in perspective, and so if that is true, that it was a late addition and they didn't really study it, then I think all the more reason for the courts to really rule on it and to say, we shouldn't allow laws like these then. So yeah, I mean, I've heard that.
All right, thank you, sir. Thank you, Maria. Thank you, Bea.
Mike.
Can I have, sorry, go Maria.
No, I just said thank you. Go, Leah.
Okay,
Sorry
Leah, I have a
to-
follow-up.
Yeah, sorry to fixate on this no. Pero like for example, if I am kunyari, a group of an internet advocate or a group of journalists, and I am deeply alarmed by interpreting screenshots as a cyber libel, would I have any recourse to challenge that interpretation if I don't want to wait for Maria to be judged just for the Supreme Court to rule on it, and I want to challenge it now? Do I have
No.
any recourse?
No, unless you file a facial challenge, which has already been ruled upon by the Supreme Court in the Dicini case. The Dicini case was a facial challenge, and the court said cyber libel is constitutional, and so that's why we're here at the as applied challenge. So it is an as applied challenge now because there is now someone being prosecuted under cyber libel. So if a group wants to challenge it, they can't challenge the finding of the DOJ because they're not charged. They're not the accused. They have no interest in challenging it. So until they themselves are accused, then they can challenge it. But if it is a facial challenge, then they would have to challenge cyber libel as it is, as it stands, and they would come up with problems of standing again, because if they raise it, then since 2012, there have been rulings by the Supreme Court on standing, and that. It's become infinitely more difficult now to go directly to the Supreme Court because of that particular case. And so, standing is a question. And so, right now, these are all as applied challenges, and we will raise them as they come. But if a group of people wanted to question the interpretation of the DOJ as applied to Maria, they might not have the standing to question that. They cannot intervene in the criminal case unless they themselves are accused. So, if they want to question it, the best way to do it would be to, get a defamatory post. And I'm not saying they should do this. Get a defamatory post, get sued. Then they can question it.
Sir, parang that sounds a little bit parang we're all just waiting to be charged under that interpretation, and meanwhile Maria will
nawala. Meanwhile, Leah will go to jail.
I think she froze. We'll just call na lang Lian if her internet is back. But if anyone has any other questions,
I can probably speculate what the end of that question was. And so yes, no choice. We have to wait. Yeah, I can speculate. The end of the question is, in the meantime, Maria has to face this charge. And yeah, but that is the reality of an as applied challenge. That is how it is. The court, again, in 2012, the court had the opportunity to rule directly on constitutionality. The court did not agree with our arguments that it is facially unconstitutional, and so we are now at this stage where we are facing as applied challenges. That is the way it is. So until someone files a facial challenge again to the Supreme Court, and I'm not saying it cannot be done. I'm just saying it's infinitely more difficult now because of the intervening cases that have been decided by the Supreme Court. We will have to face as applied challenges. So, for everyone who is concerned about this case, well, it is for us to monitor what's going on, because again, it has now become a very important issue. If, for example, this case progresses and it goes to trial, then it really now becomes a test case for that particular portion of the Vicini case, Vicini ruling.
Thank you.
Welcome.
Yeah.
Do we have questions, pa?
Yeah, very briefly. Are there similar pending cases that have, more or less that also involve retweeting of a screenshot that you are, aware of, or are there resolved cases at the, RTC level that also involved retweeting a screenshot and got sued for cyber libel? I'm just curious.
Sorry, Mika, I wouldn't know
Yeah.
of all the cases in the RTC level. As far as the Supreme Court is concerned, I am not aware of any case directly involving cyber libel for retweeting a post made on social media. So to my understanding, this prosecution is the first on that issue. I may be wrong, because there are many cases that I'm not aware of, but to my knowledge, this is the first.
Okay, thank you.
Do we have questions, pa? Because we are running around 40.
Hi, Bea. Just a quick question for Attorney Te
Go
on the
ahead.
procedure lang. Hi. Sir, just going back to December 11, how quickly do you think the judge can rule on the motion to quash? Or it's really difficult to say at this point?
I don't know. I really cannot say. Sorry, Karen. I really have no idea how long,
Right.
It's not a function of efficiency. It's also a function of how many cases the judge hears on her docket. It's how much capacity her court can handle.
Right.
The judge is an assisting judge. This is not a regular court. So again, we don't know. I'm sorry. I really cannot give you an idea.
Right. Thank you, sir. Sir, I hope you don't mind me asking, just so we don't get our facts incorrect. I know Maria's facing a lot of cases, and as you said, this is your 9th arrest warrant, and I guess it's really hard to keep track. If you don't mind, sir, if you could just give a breakdown of the pending cases and the status, which ones have progressed, which ones were the cases where Maria's been arraigned, and the like.
I'm not handling all the cases.
Okay, but
Karen.
at least
So,
the ones that you
the only
oversee.
ones I'm handling are cyber libel cases.
Okay.
Yes.
Thank you.
I can send the link. We actually have a story on Rappler. It's a running
Thank
tally
you.
lang of the
Thanks,
cases
thank you.
and the status so far.
Thank
If you don't have any more questions, I think there, Lian linked it in the chat. That's a running list of the cases that we have. So if you don't have any questions, I think we can wrap up in a bit. If meron pa, maybe 1 or 2 na lang.
Can I just
Okay, go ahead.
So Bea, you'll send the list of the cases.
Yes, it's there actually in the chat.
Oh, great. You already did. Okay, fantastic. I was just going to go through. ACRA is handling the other cases, like, the mother case. So
Yes.
I think it's 3 buckets. The cyber libel, there's these. Then the tax evasion, there are 5 tax evasion cases. And then there's I call them securities fraud. This would include the anti-dummy, the original mother case. But in terms of criminal charges, right there, this is now my ninth. And that would be 8 criminal charges for Rappler.
Okay, if you don't have any more questions, we will end here. I will message you the link to this recording as soon as I have it na, so that you can download it and you can use it for your broadcast. Yun lang naman. I think, okay na tayo, guys? Are we good?
Mike is back. Thank you, guys.
you.
Thank you for
Thank you.
Thanks, Maria.
Thank you. Thank you.
Thank you.
Take care, guys.
We might see each other in the 11th. Yun. Bye, guys. Thank you.
Thank you. Thank you. Bye-bye. Bye-bye.